Good morning. Thanks for joining me on the Meg Ellison Show. If you've missed any of the programming during the course of the 4.5 hours of gold, you can go out to WSAU.com and all of the conversations are podcasted there. Joining me this morning, again, this week, how about that? Our friend from Wisconsin Institute for Law and Liberty, attorney Skylar Croy. Good morning, Skylar. How are you?
Good, Meg. Thanks for having me on your show twice this week.
Yeah. Well, and I was just going to say, gosh, it was kind of like almost yesterday that we talked. And I believe, if I'm not mistaken, that perhaps I don't want to take too much credit for this, but I was the right amount of, I had the right amount of cynicism in responding to what you were reporting initially was that the Wisconsin State Bar had responded appropriately to a lawsuit that you were suggesting was going to happen if they did not change their practices around the DEI topic.
Right. So after I spoke with you, the State Bar put out a second press release, and one of the things they said in that is that the new definition of diversity that they've agreed to adopt, which never mentions race or any other immutable characteristic, still somehow includes race. So we wrote them a letter and just said, well, if that's your guys' position and you're going to keep taking that publicly, there's potentially going to have to be follow-up litigation. And we have different options about what that might entail, but it's really upsetting. Frankly, it just shows that the State Bar has been controlled by left-wing special interests for a long time. And just to give your listeners some facts so they can judge for themselves, the executive director of the State Bar, Larry Martin, used to be the executive director of the Democratic Party of Wisconsin.
Oh, so that's shocking, Skylar.
Right. So when I say that this supposedly nonpartisan group is not actually nonpartisan, there's something to be said for that. So just kind of my quick call to action for your listeners, if any of them are lawyers or even if they're not lawyers, I would really encourage them to just write to the State Bar and say how disappointed they are that the State Bar is still using a definition of diversity that, in their opinion, includes protected classes under the law.
It's so maddening, Skylar. I mean, but it's really not. I'll go back to my cynicism. I'm just not particularly shocked by it because if they can get away with it, they will.
I'm not necessarily shocked that they would try to do something like this. I am a little shocked that they're being as public about it as they are, particularly after a settlement agreement was reached just a few days ago. I figured that we'd at least be a year out and maybe hear through the grapevine that there are things going on that are arguably inconsistent with the letter and spirit of that settlement agreement. I did not expect it to come out 3-4 days later in a press release that was blasted on the front page of the State Bar's website. And the State Bar went a bit further. So another thing that happened that's very concerning and that's discussed in the Wisconsin Law Journal now, the Wisconsin Law Journal reported on this settlement agreement, I believe Thursday night, or it might have been Friday morning after the settlement was reached. They were one of the first people to report on it. And we've been informed that they were basically ordered to take down the story by the State Bar. The State Bar apparently scolded the Law Journal and was very upset. And remember, these are state actors that are supposed to have respect for the freedom of the press. That thankfully, and I have just a whole new level of respect for the Wisconsin Law Journal. They stood true to the story and they said, no, we'll add your perspectives on it, but we're not going to take down the story. And just yesterday or the day before, the Law Journal actually published a follow-up story about how the State Bar tried to intimidate them into taking down a news article.
Well, again, not surprised, but I mean, this is, I guess, business as usual for those on the left. And I mean, you and I talked about this off air, but the, I mean, what is the value or role of the state bar of Wisconsin to begin with?
So one thing that I want all of your listeners to realize is that mandatory state bars are a relatively recent invention in U.S. history. I think the Wisconsin State Bar became mandatory in the 1940s, right around there. Might have been 1948. And before that, there was not such an organization. And uh, there were concerns about how, and by the way, many states still do not have mandatory bars. But in states that do, there have been lawsuits about whether this violates the freedom of association or potentially the freedom of speech, because, of course, you have to pay money to fund these organizations, and then these organizations do things with that money. And those lawsuits came to a head in a U.S. Supreme Court case called Keller. And Keller basically said, at least for right now, we're going to allow states to impose these mandatory bars, but the mandatory bars need to actually focus their activities on improving and regulating the legal profession. And frankly, a lot of stuff that's happened since Keller shows that bars are not particularly great at staying within their own lane and doing what they're constitutionally permitted to do. And not very long ago, the U.S. Supreme Court, in a decision called Janus, said that teachers' unions, not just teachers' unions, public unions in general, can't compel membership. So you can't force someone to join a public sector union as a condition of employment because that violates the freedom of association. The day is going to come, and I think it's going to come sooner rather than later based on what we're seeing here, where the U.S. Supreme Court is going to say the same thing about state bars, because the state bar basically is operating in many ways like a union for lawyers, and it's imposed by law that we have to join this union of lawyers. And so far, the U.S. Supreme Court has denied these cases, although there have been dissents. I believe both Justice Thomas and Justice Alito have dissented in some of these denials of grants to hear cases. So that the day's coming, and if they keep doing stuff like this and people keep it in the media, we are just no longer going to have mandatory bars, which would be great.
Gosh, I gotta wonder how the Wisconsin Supreme Court current I don't even want to say occupants, current, we sometimes call them the four horsewomen of the apocalypse, how they would respond to something like this. I mean, this is and it's interesting to me, Skylar, that there's such a hypocrisy on the left when it comes to what should be required of I guess everyone, and what is not required of everyone. And they're so inconsistent in the forced I guess forced membership in certain organizations, like as as you use the example unions, but then even with the state bar, and I guess requiring any practicing attorney, because as I understand it today, any practicing attorney in Wisconsin must join the state bar, correct?
Yes, that's absolutely correct. And let me give you a really interesting fact. So this is probably the one time I'll ever be on your show where I say anything nice about the late Chief Justice Shirley Abrahamson. Okay,
Oh,
and
all right.
for your listeners who don't know, she was kind of the queen of left leaning jurisprudence in this state, and was actually considered for the seat that I believe ultimately went to Ruth Bader Ginsburg on the U.S. Supreme Court. She actually dissented in the 90s to attempts to that there was a period of time where the state bar was voluntary and then was going back to being mandatory. It was kind of a mess. She actually wanted the state bar to be voluntary. And her argument for why it should be voluntary is that she wanted them to be able to do a bunch of partisan political stuff. But she at least realized if they were going to do a bunch of partisan political stuff, you couldn't force people to support that. And that, frankly, in some ways, and I'm sure the bar today would disagree with me on this strongly, in some ways, it would actually be better for the bar to be voluntary because then you're not going to have organizations like Will throwing a fit every time they take these partisan stances. Because guess what? Voluntary organizations get to do that. So it is interesting because once upon a time there was some recognition that by the left that this needed to operate differently than it is right now. Unfortunately, those principles seem to have evaporated over time.
Yeah, it's just they're all in lockstep. And I mean, I remember Shirley Abrahamson. She was kind of an old battle axe, and she was very notoriously far left, but she got that one right. That's for sure, Skylar. I was not aware of that. And I mean, it makes sense that people should have the choice and not be compelled to join an organization that doesn't represent them.
Yeah, I mean, this is very basic stuff, very basic stuff. And remember, people have a right to earn a living. That is something that I thoroughly believe. And now that right is being conditioned on paying hundreds of dollars a year to an organization that is then going to go spend it with a partisan bent. And this is the biggest problem with all of this. The state bar is so ingrained in its way of thinking, Meg, that it doesn't even realize that it has a partisan bent. I actually don't think it knows. It doesn't realize how partisan it is. And that's the real scary part here. I think the state bar thinks that it's nonpartisan.
Well, and I guess if you are caught up in your own bubble and you surround yourself with like minded people and you never ever exit that like mindedness, I guess it makes sense, but it is disturbing. I don't know if you, I mean, kind of a tangent, Skylar, but, and, you know, I won't go too in depth on it because you may not have seen it, but there was recently an article published in the Free Press. I don't know if you read that about NPR and how they, I mean, how far gone they are. This was actually an article that was written by an NPR, someone that worked for NPR, and they acknowledge, or this person acknowledges that. I mean, here's one of the things during a meeting with colleagues. I listened as one of NPR's best and most fair minded journalists said it was good we weren't following the Hunter Biden laptop story because it could help Trump. And, you know, and I guess it gets to the point where uh, they don't even want to, they're so insulated. Those on the left are so insulated that they don't even realize how hyper partisan they've become because they're just so caught up in their own little world.
Well, and the flip side of that, Mag, is that conservatives are scared to speak out. I was on Vicki McKenna's show yesterday and I talked at the end. It takes some guts to go sue the state bar. And it even takes guts to write them angry letters and say, hey, you guys need to knock it off. Now, my hope is that as this kind of stuff is talked about in the media and people realize it's being done, I hate to use this term, but it creates a safe space for other conservatives to speak up and it makes them feel comfortable doing it. Because right now, I think a lot of them uh, just don't want to, and it's easier not to. And this kind of goes back to my call to action. Again, if you have listeners that are lawyers or even if they're not lawyers, I would strongly encourage them and respectfully request that they consider contacting the state bar and just letting them know, hey, I don't like what you're doing. I think that what you're doing is wrong, because you're absolutely right, Meg. These people live in a bubble. Again, the executive director of the state bar used to be the executive director of the Democratic Party of Wisconsin. That, I think, that kind of says it all. And that's who these people have surrounded themselves with. And I think they sometimes just don't even realize that there are opposing views, or they think that people who have opposing views are extremists or radicals or something like that, which is, of course, not true. But that's how I think they often view it.
It's ironic because we are talking about diversity. And for those on the left, I mean, I observe this all the time with even just in our some of our local elected officials, including the outgoing mayor of Wausau. There's no diversity of thought, none whatsoever. And I mean, they proved that during this sham of a resolution a few years ago when they claimed they wanted to declare Marathon County a community for all. But it was really, when you dug deep, it was really a community for the like minded.
Mm. Well, and I think they proved it again here with how they responded to this settlement agreement. Again, this settlement agreement requires them to define diversity in terms of interests, experiences, and viewpoints. Now, how do you get from that to a statement, a public statement, that that definition, of course, it includes race? I that's very strange. There's a couple of logical leaps that are being made there that aren't entirely clear to me. I guess that the idea is that you can just assume and use stereotypes that if people have a particular race, then they must have unique or rare perspectives or viewpoints or experiences. But why? What is the basis for saying that other than just stereotypes? And by the way, the definition of diversity that they adopted requires them to make decisions, quote, without regard to stereotypes. But again, they don't think that that sort of thinking is stereotypes. They don't they don't understand that point. So I guess a lesson learned here for Will is that if we go do settlement agreements in the future, whether it's with the state bar or another entity, we're going to have to really spell this out for people. I thought the state bar got this, but apparently we're going to have to micromanage this stuff to just no end. And it's unfortunate because I don't want to have to tell people they need to adopt a half-page long definition of diversity, but maybe that's the way it's going to have to be.
And I just I go back to how insulting it must be for someone who's non-white, because obviously this is who they're targeting in their language about this particular program, is that it tells someone who's non-white that they're not capable of achieving anything without some sort of special accommodations, and that they would not be able to, they don't have the ability, or they don't possess the characteristics necessary to achieve what evidently a white person can. And it's really disappointing that people fall for that. And I most certainly see right through it how hypocritical it is, and really, I guess I would say, insulting to someone who has the ability to achieve whatever they want to achieve, regardless of how they look on the outside, regardless of the color of their skin.
Well, let me give you another nefarious thing here that I actually don't know the answer to. I would love for a reporter to call the state bar and ask them this. But their language that in their eligibility criteria that they agreed to take out when they say with backgrounds that have been historically excluded from the legal field. What precisely do they mean when they say with backgrounds that have been historically excluded from the legal field? Because the position that they've taken all along and they've maintained at all points throughout this is, well, that doesn't really mean race. And it's like, well, but then what do you guys think it means? And they haven't really given a real answer to that. And part of the problem is when you start to say things like that, now you're basically placing the burden of interpreting this vague phrase on law students who are reading that. And how are they supposed to know? So, for example, the Harvard University lawsuit that was brought by Students for Fair Admissions, where the U.S. Supreme Court said, well, we're going to strike down affirmative action. There, Harvard, when they were favoring minorities, let's be clear about this, it wasn't all minorities. The people who were most hurt by that policy were Asians, because Harvard University, if they did a true merit-based selection, would have had a lot of Asian people, and Harvard saw that as a problem. So if you're Asian and you read language like that, is an Asian person, quote, from a background that has been historically excluded from the legal field? Or is that language being used explicitly because it's trying to encourage certain minorities and not other minorities? I don't know. No one knows what that language means, Meg.
Maybe it has to do with people with a criminal background and they're trying to be more inclusive. So someone who traditionally wouldn't consider going into the legal field because they have such an extensive criminal record, maybe they're just trying to uh, extend the olive branch to those. Of course, I'm being sarcastic or facetious in that, but I mean, I don't know. It's that preposterous, and for it's called suspending logic, and I just do not participate in that. I mean, that's what we're being asked to do, and it's ridiculous. And I hope that enough people make a mockery out of the State Bar of Wisconsin so that puts them out of business, and it's not necessary to, as a practicing attorney, to even have to join any longer, or an alternative to the State Bar of Wisconsin. We were talking about that off air. Maybe as there is an alternative to AARP, there should also be an alternative to the State Bar.
There should absolutely be an alternative if there's going to be a requirement to join an organization like this at all. I think that competition is always good. We've seen it with things like school choice. There have been studies that show that actually improves public schools. We'd see the same thing here. The State Bar and its competitor, if there were a competitor, would have to compete for membership and compete for dues, and they'd have to be responsive. And by the way, this would actually be a pretty easy thing to do, because the State Bar doesn't actually do that much. So it issues what are called State Bar numbers, which you have to use when you sign documents. And it also collects the fees that are paid each year. But other than that, I mean, so what? It puts out a magazine. It does some continuing legal education. So do many other organizations. And people don't necessarily realize this, but there's 3 different agencies in Wisconsin that are responsible for regulating the legal profession. The first is the Board of Bar Examiners, which is not the bar. The Board of Bar Examiners is a different entity, and they're the ones that decide who gets to become a member of the bar. And then there's the State Bar that issues numbers, membership numbers, and collects the fees. And then there's the Office of Lawyer Regulation, which prosecutes attorney misconduct. So if you cut the bar out of that and just give that issuing of membership numbers over to, say, the Board of Bar Examiners, that would be real easy to do.
I just want a freer country. That's all. I just want to preserve our freedoms and have the ability to choose. Skylar Croy, we're over by a little bit, but it was well worth it. Thank you for the update. Thanks for all that you do on behalf of Speaking of Freedoms, on behalf of our freedoms and liberties here in Wisconsin. Keep me posted on this. And, your client, Daniel Sir, I've had him on as a guest before. Send him a little message and tell him I'd love to have him on again as well.
Okay, I will let them know that. Thanks,
right.
Meg.
Thanks, Skylar. Have a great day. From Wisconsin Institute for Law and Liberty, Skylar Croy. If you have any interest in learning more about Wisconsin Institute for Law and Liberty, you ought to go out to will-law.org. Got to take a break. Rolling to the 9:30 news, followed by your calls. On the other side, 715-845-2155 on the Meg Ellison Show on WSAU.